I assume you might be new board members, you might not be. But either way, it's always good to refresh, even if you are not brand new to your role. But we thank you for joining us here at AKAM. I am joined by the lovely Leah Bloomberg, who is a partner at Vallely, Mitola, and Ryan. Welcome. And our lovely Ivana Pavlica, who is a managing director here in our management department at AKAM. And I am Elise Rosemarin. I'm a senior vice president here at AKAM. Thank you so much. All right, let's get this party started. So today on our webinar, we will be discussing board member operations, board member duties, working successfully as a board, which is very important, and then we'll be doing a Q&A. We did receive some questions prior to this webinar, and if you do have questions as we go on, we'll try to incorporate them throughout, and if not, we ask that you save them for the end, and we will definitely get to them. If we do not cover every topic you'd like us to during this time, we please invite you to email us, and we will get back to you as soon as possible. So thank you again. All right. So we're going to discuss corporate documents for co-ops and condominiums, amending corporate documents, what that entails, board action and voting, how does one do that? Board meetings, agenda, minutes, what is that, how often should be meeting and how do you handle those things? And then distribution of documents, what is correct procedurally? A lot of this has legalities, so I'm going to hand it over to Leah and ask you to kind of entail what are corporate documents, what's the separation for co-ops and condos, and what are the differences, just in case someone who's a new board member doesn't necessarily understand the basis of those.
Sure.
Thank you
Hi,
for
everyone.
joining us. Yes.
So we'll talk about the differences between co-ops and condos first. With a condominium, everything starts, everything starts with an offering plan, and that's how buildings come to be qualified as co-ops and or condos. But within those offering plans, you have governing documents that we then refer to in the day-to-day operations of the building. So for a condominium, you would have a declaration, which is usually the definitions of the portions of the building, what is, the particulars of a unit versus common areas. And then you have your bylaws, which talks about the day-to-day governance of the building itself, the board, unit owners, and everyone's various responsibilities and obligations. With a co-op, it's a bit different because a co-op is not real property. You are essentially purchasing into a corporation, much like you would go buy stock in the stock market. You are purchasing shares in a corporation, so you become a shareholder. And so you have bylaws for that corporation, which is your corporate governance. But then separately, as part of your perks, let's say, of being a shareholder in the corporation, you then get permission to live in one of the corporation's apartments, and you obtain then a proprietary lease that essentially creates a landlord-tenant relationship with the corporation of which you are a shareholder. So when you buy into a co-op, you get a stock certificate that says that you own the number of shares in the corporation. And then you also get the proprietary lease that gives you your do's and don'ts of residing in the apartment as if you were a rental tenant. And so with a co-op, you have the bylaws for the corporation and the proprietary lease, which governs, how you live in and go about your occupancy in the apartment.
Thank you. That was great.
Sure.
A lot of people join to change said bylaws, and they might not be happy with status quo, which might be the reason why they joined to begin with. Can you describe, what does that entail, and how difficult can it be to amend corporate documents?
Sure. So every building has their own rules and requirements for amending bylaws or proprietary leases. In a co-op, we would do both at the same time, just because the proprietary lease often refers to the bylaws and the bylaws often refer to the proprietary lease. So if we're going to attempt to revise them, we do them together hand in hand. In a condominium, it would just be the bylaws. Each building has its own, like I said, requirements for amending these documents. Most I'm going to say is about 66 and 2/3. Some are even higher at 75%. And so the threshold is really high. And the reason that is because you don't want people changing the governing documents willy-nilly. It's usually one big concerted effort. Like we deal with a lot of them, especially since COVID, to kind of bring everything into the 21st century, allow for remote meetings and remote voting and participation from people that might not necessarily live in their apartment or be there full time. And so we go about amending these documents, usually in one full swoop, to address any overarching issues that the building has at the moment. Or you can simply do a pointed amendment and, let's say you wanted to revise your flip tax and everything else is totally fine. You could draft an amendment that just addresses the flip tax.
So actually, it's a great example. How difficult are certain bylaws to amend? And what are some examples of maybe more simple ones? And then, Ivana, from your standpoint, how do you work with boards to help them understand when they might be crossing the line, or maybe how do you communicate to residents that we'd like to make these changes? So, I guess two questions.
So I'll start with the first part. Depending on how high the threshold is, 66 and 2/3, 75%, it's high either way, and it is an often difficult task. Not only to get participation that is that great. Some of you might have experienced where you have annual meetings and you're, holding your breath to get a quorum of 50%, let alone to reach 66 and 2/3 or even 75. So it is an often difficult feat to get there. But what we typically like to do, at least when I'm involved, is try to get the word out there well in advance of the meeting. So if we're planning on doing an overhaul of governing documents, we'll start with a red line revision that gets circulated to all the unit owners or all the shareholders months before we're planning on having a vote. We'll have a town hall meeting so that those residents or shareholders can come and ask questions about it, and we could explain why we're proposing these changes and what the ideas were behind it, and see, kind of test the waters and see if we're getting good feedback from the owners, or if there are issues with it. We might go back and redraft some things based on the feedback that we've gotten. It's certainly not something that happens in like an overnight throw it together, see you in a week at the meeting type of thing. This is something that usually takes months, if not even a year or more, to kind of get through because of how difficult it is to gain that sort of support. And I'll let Ivana talk about how she communicates with shareholders to get there.
Right. So I am completely on board with Leah. I've seen successful amendments go through on either proprietary lease or bylaws when they are communicated well in advance. So, for example, if you are contemplating any sort of amendments to your proprietary lease or bylaws that you may feel might be controversial or even difficult to even get responses from owners and shareholders, I've often seen boards announce that they want to contemplate certain amendments and share which ones they're contemplating to change a year in advance. They will not bring it forth at their current annual meeting or try to put it on the agenda for their current annual meeting or even call a special meeting for it. They will start talking about it in advance. So, for example, if your annual meeting is next month, that's when you would mention it. You wouldn't bring forth the vote. And then there has to be some involvement and communication and sort of like I would call it like a grassroots effort from the board and maybe other shareholders and owners who are on board with some of these changes, because the purpose of these changes is to improve something, not to take away, right, from your building. So I would highly encourage that additional communication. To what Leah's point said, town halls, those can be virtual in case there is an issue attending in person or you have owners who don't live full time in your building. Those are really helpful methods. I actually can give a real life example. I have a co-op that managed to amend about 7 provisions in their proprietary lease. They had a very high threshold of 75%, not 66 and 2/3. And the way they successfully amended 7 of these provisions of their proprietary lease is that they announced it at a previous annual meeting. They left voting open. They were remained available for questions. They actually assigned one board member as the person that would field any questions. Shareholders could call them, and set up a meeting with them. And we had these 7 amendments pass fairly easily, actually. And we met that threshold. So it was very successful. Um, in terms of when to bring these up, annual meetings for sure. If you have to, call a special meeting for it. Special meetings are kind of just like annuals, but they're called for a specific purpose. Leah can actually go into what those are if anyone is curious. Um, but that is the level of success I've seen. As far as what to be careful about, and if perhaps an idea is barking up the wrong tree, um, send surveys to your shareholders and your owners. Get sort of like a temperature reading. If you have Building Link, it's very easy for your manager to send out a communication on Building Link. Or you can even set up a Google Forms. Very easy, gives you the data like pretty easily. And so you can get a sense of where your shareholders or your owners are landing on some of these subjects. Uh,
Yeah.
Anything else?
I was going to ask, Leah, you mentioned a flip tax. So, how does one, you want to do a flip tax, or you've had a flip tax and it's not, creating enough funds. What is the next step as a board member? This is not your job. So who's supposed to navigate that for you and tell you, this is what we're seeing on the street. This can have a negative impact. This can have a positive impact. Whose role is that from, a fiduciary standpoint and just, a knowledge provider?
I think it's a concerted effort between what I call the trifecta, which is the board, the management company, and your attorney. I think we all kind of work hand in hand. I'm actually in the midst of doing this with one of my co-ops right now, where they have a very antiquated and very odd flip tax, and we are working to modify it to make it a bit more consistent across the board and easier to not only apply, but to collect and to explain. And so in doing so, I have essentially laid out the common types of flip taxes that I draft into these documents. The board will, consider the different options. And then management will usually weigh in on what they see in neighboring buildings, whether they represent them, or sometimes even board members will go out and ask their neighbors. So like one board president might know the neighboring board president and say, hey, we're considering updating our flip tax or incorporating a flip tax. What do you do in your building? Type of thing. And so I kind of think to get a great result, I think it takes all three to kind of work it out together and weigh the options. And then, of course, like Ivana said, you bring it to the shareholders to see if it's even going to pass muster with them, because there's no point in bringing in a vote for an amendment if it's destined to fail, right? The legal fees that are incorporated, the time that the board spends on it, the time that management spends on it, it's all for naught if it really has no likelihood of passing. So the idea is to kind of get everyone involved and see what's going to float.
Can you kind of just do it? I think there must be times where people are like, do I really need to amend the corporate documents? Are there certain things I can get away with, or certain things that we can get away with as a board where I don't need to put it in writing and just put, or what are the ramifications for doing that?
I think with things like a flip tax, it has to be, adopted into your governing documents. You can't just turn around and say, hey, you owe me 2% on everything that you sell. There has to be some sort of legal justification for that. And you look to the governing documents in order to accomplish those things. Without that documentation, there is no justification, and a shareholder could just as easily say, well, there's nothing here that says that I have to do that, right? So governing documents are what guide us through pretty much everything when it comes to running a co-op or a condo. There are house rules in both co-ops and condos that the board can adjust by majority vote that does not require shareholder or unit owner participation. But that's usually more for the stuff that's kind of like run of the mill, as far as like not keeping things in the hallway, not hanging things outside of your windows, if there's quiet hours in the building, stuff like that. But where things impose, a financial burden or financial imposition on unit owners, it's not something that can just be passed through a house rule. It's going to have to be deeply embedded in your governing documents. And that's exactly why the threshold for amending them is so high, because it has to be an overwhelming majority of owners that are in support of these changes.
Yeah, and just to piggyback off of what Leah said, a co-op or a condo board can run into serious legal trouble should they try to impose these things that are not in your governing documents. A shareholder, a unit owner can actually bring forth a lawsuit. They could claw back a flip tax that was not properly passed or amended in your governing documents.
So if you
Thank
see
you. Yes.
on, I guess, see something, say something.
Yes.
Yes. So getting people to do something is probably more challenging than getting them not. So how do you handle voting, especially nowadays where, not everyone congregates in person? That's an anyone question. What
I'll
is that?
take it.
What does that
I'll take it
I was
because
going
I'm
to say,
usually
Ivana, you're usually the one
it's
to chase them down. I'm
yes,
just
I
usually there
am.
making sure it all adds up.
Yeah, so you can provide electronic voting options. Building Lake actually has a platform for that. I believe there's a few others that allow it. As your managing agent, we will offer you several options in getting back your directed proxy ballot or your ballot. Either we'll have a box placed in the lobby, we'll ask you to email it, or we'll ask you to mail it to our corporate office. So we offer all the options just to make it as easy as possible for owners and shareholders.
sometimes there's contention, right? So how do you make sure that these votes are not like, oh, the managing agent is trying to sway it, or oh, and that's not true a lot of the time, but that does come up. So how do you, especially if there's a contentious vote happening, what are your recommendations as a new board member, something that you should be thinking about doing maybe to make it less contentious?
Right. I mean, if you think it's going to be very contentious or if there should be no doubt cast, then we would recommend to the board to hire a third party company that actually specializes in collecting proxies, ballots, handling the attendance. These companies do it for fee. Honest Ballot is one of them that's super reliable. That's where I would recommend if a board feels that their audience is very split.
And I was going
Happen
to say
often.
there's like a half step before that where most governing documents will also provide for inspectors of election. So you could appoint, let's say, your attorney to oversee counting of ballots and votes and whatnot as the inspector of an election, just to make sure everything's running smoothly. Normally, managing agents will be the inspectors of election, but if you have a group of shareholders that are worried about, management's participation or biases or whatnot. I mean, attorneys have a legal obligation to comply with the terms and conditions of your governing documents. And so we're usually the next string of inspectors to come in and kind of oversee things. And then, like Ivana said, if all else fails, you can hire a third party. But for those looking to conserve those fees, I'm usually at your annual meeting anyway, so I might as well be overseeing the counting of the votes.
Right. Um, so let's talk about board meetings. How often are you supposed to meet as a board? Who sets the agenda? Who takes the minutes? What are the steps, especially as a new board member that might not know what is expected?
So your governing documents will say how frequently the board needs to meet. Usually it's monthly. Some boards will meet as needed if there's a purchase application that comes in and they need to meet more frequently to discuss it, or obviously if there's an emergency or something that requires them to meet more frequently than that. But most boards, I will say, meet monthly or should be meeting monthly. Some meet quarterly. It really all depends what your governing documents say. And I'll let Ivana talk about, who calls the meeting, who sets the agenda, because that's lending itself more towards management.
Right. So typically speaking, the president of the board should really be setting the agenda, but very often your managing agent is the one helping you do it. We understand that you are in a volunteer position and likely have a full-time other job. That's why we're here to make it easier on you. So oftentimes either the board will just ask the manager to set the agenda, send them a draft, prepare the whole package. Other times, the manager will work with the board president in tandem and maybe another officer of the board to finalize the agenda and then circulate the entire board package over to the rest of the board.
Right. And then as far as taking minutes are concerned, should you over communicate the minutes? Should you make them as little as possible? Can you discuss how that's taken and how much to include?
I think there's a happy medium because it's important to note a few things. One, the minutes need to accurately reflect what's being discussed at board meetings. And you do owe, a sense of transparency and honesty to your unit owners, shareholders, and they do have the right to review the building's books and records. So they have the right to come into management and look at minutes. So to that end, I would say you want to include information because you want your unit owners and residents to be aware of what's happening at the building and not just show up once a year for an annual and be surprised about what's gone on over the last 12 months. However, I think there's also an expectation of privacy a bit when it comes to minutes because minutes are also being circulated for review to prospective purchasers. And so you have a buyer's attorney coming in to look at a building to determine whether or not it's a good fit for their client. If there's any, liabilities, if there's any chance of a massive maintenance increase or assessments to be imposed, and things that buyers' attorneys want to know so they can accurately caution their clients. So there's a lot of information that then gets transmitted out to the public because these buyers don't necessarily then buy in your building. They've been made aware of all the details of your building. And so, when things, I typically things like arrears, typically things like if there's some sort of problematic issue with a particular resident in the building, I will say to refrain from including a lot of detail on those things, but stuff like, capital improvement projects and the board considering whether or not to increase maintenance or hire a new contractor for a job, those types of things are items I would want to include because not only is it good for prospective purchasers to know what's going on, it's also wonderful for current residents to know what's happening in the building as well. And it helps prove the point that the boards are doing their job and not just getting, sometimes being on a board can be a thankless job, and you want to show your residents and owners that you are, in fact, actively working on bettering the building and its upkeep.
Right.
Yeah, and as far as who's taking the minutes, that should be the board secretary. Um, there are often times where your board is asking your managing agent to take the minutes for you. You can swear in your manager as assistant secretary. They can certainly do that for you. Or the assistant manager can take the minutes, but typically they do it for a fee.
All right. And then how does that all get distributed? And where do you record these documents?
Leah, if you want, I can tell you what I do from the management side.
I was going to say, governing documents will say that all of these things need to be on account with the building's corporate offices, which is usually the managing agent. And so, back in the day, and I'm going to age myself here, when I used to represent buyers and I would go into managing agents' offices and they would have these massive binders of minutes and you would go back into hard copy minutes and sort of review all of that. Nowadays it's digitized, or I would hope most of it is digitized. But I'll let Ivana talk about, how you can access that and stuff.
You are correct. It is digitized. We
Thank
really
goodness.
like to save the trees. There is a much easier way. It actually saves somebody a trip from scheduling with our corporate office. We actually have an online way at AKAM to allow for minute review. There are certain boards that will email PDFs that are protected of the minutes, the monthly board meeting minutes out to their shareholders or their owners. But majority of them will just save them to file. And if there is a request, then the request should be made in writing to the managing agent and will facilitate the viewing of said minutes.
Right. And so if someone is trying to look back in a building's history and get themselves up to speed and who made what decision when, they can access the former documents with you, presumably that, the agent, if you moved over to AKAM recently, had kept good notes and all that. But it should be all digitized. Great. All right. Moving on to the next set of duties. All right. So you're a board member. You now have fiduciary duties and liabilities, which can seem onerous, but there is definitely a positive to being a board member. What are your fiduciary duties? Do they differ in co-op condo? And what are some liabilities that you should be aware of? Yeah,
So
that's definitely.
fiduciary duties, fiduciary duties are, I'm going to say the same across the board, whether you're in a co-op or a condo. When you're on a board of directors, board of managers, it is all the same. You are held to the standard of a fiduciary. A fiduciary is essentially an elevated person who is given an extra set of responsibilities and therefore an extra set of um, requirements, I'm going to say, as far as your actions and activities go. So whether you are serving on the board in just a board member capacity or you are serving as an officer, in my mind, most of the fiduciary duties are the same. Of course, there's additional expectations for a president, a treasurer, a secretary, a VP, and all of that is detailed in your governing documents. Your bylaws more specifically will have, what does the president do? What does the secretary do? So that is all laid out for you there. But the fiduciary duties are not necessarily delineated in your governing documents, and that is more that you are to work in the best interest of your building. Sometimes those interests can compete with your own individual thoughts and processes, right? But the idea is you are there to serve the greater good and that the overall building is greater than your one individual thoughts and priorities. So you owe a fiduciary duty to the building to act in the best interest of the building first and foremost. You also owe a fiduciary duty to your fellow board members. So the duty of loyalty, I think, encompasses also the duty of confidentiality and respect, and you are to, keep the conversations that occur in the board meetings by and between the board members and perhaps management or myself, and not, leave the board meeting and then go call your friend that lives down the hall that's not on the board and say, hey, I just got out of a board meeting and listen to what's going on here. The idea is that we want to encourage, or it should be expected, that board members should go into meetings unafraid to express their opinions, their thoughts, their ideas. That's why you're on the board, right? To further your, not necessarily your agenda, but your ideas for the building. And so, good, bad, or indifferent, you should be encouraged to share those with your fellow board members. Now, they might not pass, they might not gain support, but you should be encouraged to share them. And so the duty of loyalty, the duty of confidentiality, I think helps ensure the ability to come in and express those thoughts and ideas without fear that they are going to then be disseminated to the rest of the building. Similarly, when you're working on something, you're not going to then go broadcast something until the board has voted. And normally the majority vote will carry the board's decision. And so whether you were for or against that idea, once that board has voted and the majority has been cast, you as a board now are communicating that decision to the rest of the building. And it should not matter who was for it, who was against it. We'll go back to minutes for a second and say that's exactly why I don't like board tallies or who voted for and against things in board minutes. It is just simply this passed, you know, 4-3. This passed 6-2. It whatever the count is, you can absolutely put a count, but you do not need to delineate who voted for what, nor do I recommend that. The board is a unit when you are delivering messages to the building.
When it comes to
And
liabilities,
sorry, then there's conflicts of interest as well, right? And that kind of goes back to my initial point of sometimes your individual interests conflict with that of the greater good. And so where there are matters that concern you as a board member, let's say you're looking to do an alteration on your apartment and the board is going to review that alteration package, you will recuse yourself from the board meeting that discusses your alteration because, of course, you have a vested interest in what happens there, right? So anytime a particular board member is involved in an issue that is coming before the board, that individual will recuse themselves from the meeting and will not vote on whatever it is that the board is deciding on.
thank you. Yeah, so two
Sure.
questions there. So conflicts of interest, what can you expand on that a little bit? What if a family member lives in the building? Does the same rule apply that you would have to also excuse yourself from that meeting? Because it's how does that how do you handle?
Yes. So anything that would attach itself to you or that you might be directly involved in. So if your mother also lives in the building, but in a different apartment, it would stand to reason that you might have an opinion on what happens to your mother's apartment. And so you would recuse yourself from that too. It's kind of like when you think about doctors not being able to treat their own family or friends because of their emotional connection to the patient. Same kind of thing applies here. You're not going to vote or otherwise be involved in a discussion that lends itself to your own personal issues or opinions.
What
I can
about
provide another example.
Great.
It would be if you have a board member who's a real estate broker and he has been hired by their shareholder or
Yes,
an owner
the
in the
great one.
building to market their apartment for sale, that board member should absolutely recuse themselves. There actually has to be reporting per what is it, New York City governance laws noting that this board member recused themselves and how much money they may have made from the actual transaction. They should not be voting on that.
There are even buildings that require that brokers cannot run for the board because of that inherent conflict. So, if you are fortunate to serve on your board, you cannot participate where your deals are involved.
what about if you own, a carpet company and you're a board member and you want to have the board use your carpet company for your renovations? What about that?
That's a
Ivana?
bit of a conflict. The way that we would probably handle that is to get bids from several companies. If that particular carpet company comes up to be the cheapest price, that should be disclosed to all shareholders or owners, depending on if it's a condo or co-op, and move forward from there. And that board member who owns said carpet company should not be involved in any of the voting to do with that.
I actually had
There's also an annual requirement for conflicts for board members that management will, you know, distribute to all board members every year. And so the board member that might own the carpet company would have to disclose, hey, I own a carpet company. The building was doing a lobby renovation. I offered to, discount the services at 25% or whatever it was. I received X dollars for this project. They have to give a full disclosure of what they received in connection with the transaction.
I was going to say in my former building, our building attorney also was a board member. So that seems like a conflict. It
Definitely.
felt like a conflict at the time. Uh, but that I would imagine is another example. Can you outline? I know you briefly discussed it. Can we outline the officer positions? And can you also share what is typical of how many people are on the board and how do you even get elected? I know obviously people are now on the board, but sometimes it's difficult to get people to join the board. And what positions are available?
So your governing documents will usually lay all of that out. how many people will be on the board is one of them. I've seen anywhere from 3 people to 9 people. Usually it depends on the size of the building. And it, again, depends on your governing documents and what they require. Usually, when a building first becomes a co-op or condo, the sponsor will typically have 3 seats on the board. And then once it transfers over to unit owners, it will get a little bit larger. If there is sponsor ownership still, after the first 5 years, sponsors can't have control of the board. So the majority will be those resident unit owners or shareholders. And then the officer duties are typically president, vice president, secretary, treasurer. And Ivana also mentioned, you can appoint assistant secretaries, assistant treasurers. There are subcommittees that can come on and, kind of tackle all the things that the building needs. But those 4 are the main 4. The president usually runs the day-to-day operations together with management. The vice president will typically stand in if the president is unavailable. The secretary is responsible for taking board minutes and calling board meetings. And the treasurer, oversees the financial investments for the building, collection of maintenance, and so forth.
Can you eliminate positions on the board or add?
You can add in the sense of like assistant secretaries and subcommittees. Like if there's, like a hallway decorating project that's coming on, you can create a subcommittee that will oversee the hallway decorations. And that's usually led by a member of the board. Adding more than that, probably not unless you're amending your governing documents to reflect those new positions.
And then when it comes to ruling the roost, so to speak, a lot of buildings, some, not a lot, but some buildings might just defer to the president for everything, and the president makes the majority of the decisions. If you're a new board member and you join because you're not thrilled with the way that the president has been running your building and or how do you work against that? What do you do there? Because a lot of times people do join the board because they have a voice that they feel hasn't been heard. And, how do you handle a board that's been running directly through one conduit? I guess that's a management question and an attorney question.
Well, I was going to say it's more a political question than anything else. The truth is, I've seen it from both sides. I've seen the shareholder that decides that they want to run the board because they don't like what's been going on, and they come in with fresh ideas and they get shot down because that's not the way things are done here. And, there it takes a little bit more. And to that end, I would say the politics then come more into play because you need the majority in order to pass something. So it's not necessarily just a president. In fact, if a president's making all the shots and not bringing it to a board vote, I would say that president is breaching their fiduciary duties as a board member. But more so, that one shareholder that feels like everything is going through what the president has to say should find support or discussion at the very least with fellow board members to see why it is that way or why the board decided to vote that way and kind of work from the inside out. Conversely, I've also seen people that run for the board because they don't like how things are done. And then once they get on the board, they go, wow, the board is working tirelessly to do everything. And I had absolutely no idea how hard they were working, how much goes into these decisions, how much management does behind the scenes, and they gain a completely different perspective. And so, if I had $1 for every annual meeting that I was at where a board member got up and said, guys, you have absolutely no idea what goes on behind the scenes. It's very easy to be a disgruntled unit owner, but when you get onto the board, you really kind of learn how the sausage is made, for lack of a better term. There's a lot that happens and a lot that the board is taxed with that goes beyond what individual unit owners and shareholders will know about in the day-to-day.
So they're not getting paid.
And they're not getting paid.
So it's a volunteer position, you mean? And
it is a very thankless job more often than not.
Tattoos and whatever else, their name on the building, that's not happening.
Definitely not.
Understood. All right. So next, if we can do the next slide, please. All right, board dynamics. We kind of touched upon this already. But I do think this comes often and not. I think people feel that being on the board, you got preferential treatment for the people that you like, the people who you don't like. You can discriminate against people you don't like. So now you're in power, or at least that's what some people believe. What what are the, I guess, ultimately, what are the legalities about that? Who has the chain of command? We briefly discussed that, but what is the chain of command? And then, well, let's just start there.
So I think as far as discrimination and preferential treatment, I'm going to go the reverse and say I think when you're on the board, you're under an even bigger microscope because everybody is watching you and knows, your position, and therefore will know if you miraculously was able to alter your apartment without permission, or you were able to, get that portion of the roof terrace, assigned to you. I think you're under so much more scrutiny as a board member that the idea of preferential treatment is almost laughable to me. But I understand where the misconception comes. At the same time, it is illegal to treat any shareholder differently than another. And so, discrimination, there are so many anti-discrimination requirements and regulations in New York City, especially that the board has to comply with. And those things are popping up even more frequently now, with potential discrimination disclosures for potential purchasers in apartments. So that works across the board. It's not just when you're buying in, it's when you're living in the building as well. As far as the chain of commands, I'm not really sure, how that comes into play. Usually, management will run the day-to-day. Management will first consult with the president on questions. If they can't get the president, then they will get, the VP or the secretary or, a board member that you come to know which board members are more readily accessible than others. And so those tend to be the ones that you will bring issues to immediately. And then I find as we move into the digital age between group texts and email chains, you get the participation that you need from the board when you need it, as you need it. Um,
Yeah, I was going to say, a lot of times I think people join the board and then all of a sudden their doors are getting knocked on because people now know you're the person to go to, but actually it really shouldn't be. Speaking to utilizing professionals, as your role as manager, what is your interface, Ivana, with preventing, a board member now to this, overarching exposure, and keeping their privacy? It is your home, it's your investment. You're entitled to still live your daily life without having people come to you. How do you advise new board members so that way they can still maintain that autonomy that they once had without feeling imposed on?
Right. So me as your manager, I'm going to protect you as much from that. I want to say just noise as much as possible. Very often boards create a policy that if any shareholders or owners would like to speak to the board or lodge any complaints, whether it be about anything going on in the building, even the managing agent, trust me, we're professionals. We're not going to take it personally. You can send me that email. um, we will tell them to go through the managing agent, right? Like, so I will get the email and then I will make sure that the board receives the communication. The board will respond. I will liaison and send the communication back. We can also facilitate setting up calls. Very often, board members will actually use their monthly board meeting to invite a shareholder or an owner, usually one at a time, for the first maybe 10 to 15 minutes to speak to them, hear them out, etc. So what we try to do is not increase your email traffic, but lower it. Uh, and just, have a possible, sometimes I've had conversations with shareholders who have gotten too onerous and they've gone knocking on a board member's door at like 11 o'clock at night about something that was absolutely not an emergency. So we will actually step in on your behalf as your managing agent and set the tone. The most success I've actually seen is when board members are assigned certain tasks or projects, rather than one person taking on everything or the entire group sort of spearheading a project. So, for example, you have Local Law 11, maybe one of your board members is more well versed in construction and large capital projects, that person would be assigned as sort of like the board point person. Or as I alluded to before with the amendments, we had one board member assigned to field any direct questions from shareholders or owners regarding questions about the lease amendments. And that way, you kind of spread the workload and the responsibilities while remaining accessible to your constituents. And the managing agent is here to help you do that and facilitate that and just make your life easier.
Yeah, you mentioned local law 11, and I know a lot of our boards are very savvy. You know, they're CFOs, they're in the industry. It's why they joined the board. But what if you aren't? And, you know, now I'm on the local law 11 committee and I have to be at these meetings. I know absolutely nothing about this. Who do I consult with? Like, how do I, you know, I don't want to expose myself in my building because of my presence. And maybe also, again, maybe we're a small building and not everyone has that, you know, experience. So what do you do there and how do you still be an active participant? Where does management step in for that?
I would encourage any new board member to consult with management on anything they're not aware of or unfamiliar with. Like for myself, I'm happy to set aside time and just have a conference or a call with a new board member and kind of walk them through what is this thing that the city is making me do, right? Other times I will definitely encourage utilizing your engineer architect. Very often they are nerds about what their profession is. They love talking about this. They will relish the opportunity to walk you through what this is, start from finish, what it is, why it even exists. So utilize your managing agent, utilize your engineer architect.
What about utilizing your attorney? Because no offense, Leah, but the fear is you're going to ring up the bell and then everyone's going to hate me. So how do you be mindful of utilizing your professionals while still maintaining the budget?
I will tell you what I tell all of my boards, which is a quick 5-minute phone call with me will typically save you hours of legal issues later. And so, you know, for the 5 minutes I might bill you, well, I'm not going to bill you for 5 minutes, but for the 15 minutes I might bill you, it's certainly a lot less than the hours after the fact where, you know, you didn't consult with me. And more often than not, you know, unfortunately, I will get calls from board members that will say, well, we entered into this agreement with a lobby designer, and now they're telling, and I'm going, well, you didn't send me that contract to look at. There's only so much here I can do to help you, right? And so to have me take that first hour to look through that design contract would have probably saved you now hours of me trying to figure out how to get you out of it, or God forbid, litigating your way out of it. You know, so
And
I
just to
always encourage,
add to
no
that,
question is a stupid
yeah,
question. Ivana will tell you that is my motto. I encourage board members to ask me questions. I think my representation gets better the more I interact with my boards. And so whether you're going to text me a quick 2-second thing, or you know, you call me into your board meeting for the first 15 minutes just to talk about a particular issue and then kick me out. You know, I realize I'm on the clock. I get it. It's nothing personal. It's business. But at the same time, it is my job to make sure that you run your building well and that you do so legally, and to try to avoid any pitfalls that you might come into.
Makes sense.
yeah,
And who
your professionals are there to protect you. They're not there to gouge you.
Correct.
Well, I was going to say, is there, because again, there is a cost to speaking with professionals at times, is there a person or is there a process that you have to say, hey, is it okay if I call Leah? Or, you know, how I'm a new board member, I don't know.
So usually I will find that I interact mostly with the property manager and or the president of the board. And those are usually the people that will call and say, hey, I have a quick question for you. Alternatively, and like Ivana was saying before, you know, when you're doing a capital improvement project and you have an engineer on your board, that would be the person. Similarly, for legal questions, you might have an attorney on your board. And so sometimes I'm speaking with, you know, a board member that is not the president, but they are the attorney, because it's like-minded careers, and so we can kind of cut through the red tape that much faster.
it. And so when it comes to making decisions, like what I was just asking, how, and we touched on this, but I guess it's very important to present a united front, even though you might have a fractured opinion behind the scenes. It's like when you're two parents and you say no, the effect is different than when you're like, that's okay, mom. Mom says yes, but dad is saying no. So
Right.
what are your thoughts on that, and who gets ultimately to make a decision?
I think the board collectively makes the decision with a majority vote, and then depending on how they're going to communicate that response to the building, whether that's through the board communication or from management, or telling your professional how you wish to proceed. It typically, when the board gets involved and makes a vote on how to handle a situation, at least for legal representation, I will usually get an email, let's say from the board president, but with the rest of the board in copy to say, hey, Leah, we voted on this, go right ahead and do what it is that you recommended us to do.
Right. And when it comes to removing an officer or a director, obviously that might be contentious. How does one go about that? Yeah.
So governing documents will usually lay out how to remove a director, an officer, a manager. The general rule of thumb is that the board themselves can remove an officer. So that would be president, vice president, secretary, treasurer. But usually it will require full participation of the rest of the building to remove them off the board, since the building is who elected them to the board in the first place. There's pros and cons to that, in my opinion, because if you have a board member that is engaging in some sort of nefarious behavior and the board wants to remove them because, they've caught wind of that, I would much rather prefer that the board get to make that decision than have a public tarring and feathering of the person in front of the rest of the building. But if your governing documents require it, usually I will tell the board, look, you can have a conversation with this person and say, rather than calling a special meeting to call for your removal, perhaps you'd just like to, resign, and then the board can fill that vacancy.
So in a case of a sponsor, because that can also be a board member or a director that you want, out because maybe it's new construction and you're unhappy with what they did and you feel like them being on the board is, not in your best interest. How do you work positively with the sponsor? Because that's important. And sometimes it's not a new development. They have, a certain threshold of units in your building. How do you work collaboratively with the sponsor, and, how do you remove them if you're not thrilled with them?
Okay, so governing documents will dictate a sponsor's involvement on the board. In a new construction project, the sponsor is in control of the board until the earlier of they sell off 50% or more of the units or the common interests in the building, or 5 years have passed. And that is the final, like the longest you can possibly have a sponsor in control of a board is 5 years from the time that they went to condo or co-op, because the idea is to not have a sponsor controlling a building once more unit owners are individually owned, or units are individually owned. That said, there are plenty of buildings that still have sponsor presence because sponsor retains some of the units in the building and may be entitled to hold a seat or two or three for so long as they own units in the building, or they have enough ownership stake in the building to continuously vote themselves on to the board. And so you do not have a right to remove them from the board. You can call for a meeting, but my guess is if that person has, or that entity has enough votes to get themselves on, they're going to have enough votes to keep themselves there. And so removing them is not really something that I would recommend. I don't think it would be successful. And not only that, but I think it would greatly disrupt the balance that buildings that have sponsors in strike to achieve. The idea is to cooperate with your sponsor. Some sponsors are wonderful, and some boards get along famously with their sponsors, and they all have, this grand idea of doing what's best for the building, and that's wonderful. Sometimes the interests of the sponsor are different than that of the residential members of the board, and so we kind of just learn how to play in the sandbox together, and come to agreements that can be amenable to both sides. But at the same time, that's exactly why sponsors are not the majority share of the board, right? So if you have a 7-person board, even if your sponsor has 3 seats on that 7-person board, you still have 4 seats that are residential unit owners. And so if those 4 vote together, that majority will carry regardless of what the sponsor's position is.
Right. This has been really wonderful, and I really appreciate both you, Leah, and Ivana's time. It's been great. We have a few questions, so we're just going to wrap it up here. And a lot of these you actually touched upon, but I think the one that I'd like to ask that hasn't been discussed is D&O insurance. How does that protect board members, and what's covered under that?
So D&O insurance, and I'll let Ivana talk about it as well because different policies have different things, but D&O typically will cover the actions of the board so long as they've been working in the best interest of the building. You will not be individually liable, and I think that that's a huge concern for people that are looking to go, run for their board or participate in boards. You are not going to be individually liable unless, of course, you have done something so nefarious that it breaches your fiduciary duties to the board, and then D&O will not cover you. But so long as the board is acting in the best interest of the building, D&O will cover any issues or complaints that might occur.
Surprise cat. Yes, so D&O is actually super important. What I've seen typically is, it will cover a board if, let's say, a shareholder or owner is suing them, or even a renter that a shareholder or owner has rented to in the building. It basically saves you as a building a lot of legal costs, right? Because it will cover you. So like instead of you having to piecemeal pay your attorney, no offense, Leah, love you,
None.
your D&O insurance will cover you on that. And it's not to say that it's rare that a board might get sued, but it can happen. The other thing it can cover you on, and this is probably something nobody really thinks about, is if there is a housing court issue, right? I recently ran into this with one of the managers I work with, in that there was a boiler issue in their building. Notifications were sent out. It was cold. It was under 68 degrees in apartments, but we still had some owners call and complain to HPD, and HPD actually filed a court case against the building and against management. So that is where your D&O also kicks in. Your D&O will step in and assist you in defending against in that case.
What about communications outside of board meetings, like texts and, emails to each other? Are those discoverable, from a legal standpoint?
Everything is discoverable unless your attorney's on it.
So, just because you're not in a meeting and you don't like Samantha, who's on the board, and you're like, let's do XYZ, and it gets found out, you will have
1000% discoverable. A breach of your fiduciary duties, you name it, don't do it.
So, in the spirit of positivity, let's end on a positive note. What are some reasons you would want to join the board? Because it is a great thing to be, have that ability to protect your home and your investment. What are some positives that you perceive? Don't jump.
Well, you kind of took the words out of my mouth, which is you want to safeguard your investment. I've often seen shareholders or owners joining because they want to safeguard their investment, right? There's continuity. Maybe there's a board member who was serving for such a long time and now they're stepping down and somebody else needs to take their place and basically carry along the torch, right? That could be a good reason. It gives a sense of giving back to the community, or you're taking like I said, the torch from somebody else and you're continuing to give back. Again, it's a thankless job. It's a volunteer position, and it does involve a lot. Even though we here at AKAM are here to help, board members still have to take their responsibility and their fiduciary, like what we discussed before, seriously, because some of these decisions can, have impacts on the building as a whole, right? Like they do have impacts, but some of them might have bigger impacts than others, like sort of like ripples from when, you drop a rock into the water, right? Um, I would say this is a side note where it could look good on your resume if you served on the board, because you can say in your capacity that I have experience, running a whole building or working to run a whole building. So those I think would be the points. Also, if you feel like you can contribute, if you're an attorney, an engineer, maybe you're an interior designer, um, all perspectives are usually welcome, right? And the more perspectives you have on a board, the better it is. So like instead of having like, two people who are um three people on the board who are all attorneys, maybe they're specializing in different things, but there's nobody on the board that knows anything about architecture, interior design, maybe they know gardening, things like that. Um, Variety is the spice of life, right? Like it's better to have more minds and different perspectives working in together to make your building the best place possible.
I was going to say, I think it's also effectuating change, bringing about things that you'd like to see happen in the building. Especially like Ivana said, you have people that have served on the board for a very long time. Sometimes some new blood in there is good to reflect the interests of those that are new to the building, or have different perspectives. Like people that have been there for a very long time might have different interests than young families moving in, or young professionals moving in. And so bringing about new ideas and effectuating change, I think, is a huge driving force. And yeah, I also think networking in a weird way, because when you work on a board, you are meeting people in city council, you are meeting other boards, you are meeting people in management, you might be going to the co-op condo expo and meeting people in different buildings. And so it kind of just is a new vein to tap as far as, finding like-minded people or finding other people that are in your industry, and working that way as well.
Right. Yeah. And I think at the end of the day, from a management perspective, we always tell our boards, we want to make you informed decision makers. That's our job. Your job is to point and shoot. If you're doing the work, and like that's what we hear, grievances for when people are coming to us from companies, you shouldn't feel that way. It is a task, right? It is something, but there should be some sort of enjoyment in there, and you shouldn't be shooting in the dark. You should not be doing the bidding yourself. It shouldn't be onerous, right? It should be us doing the work for you all, and making you educated so you don't feel like you're making decisions without having an understanding. And that's ultimately why good attorneys and good management, which we're here today, ultimately make you a very empowered member. And that's always our job and our goal. So thank you so much, Leah and Ivana. You both have been very wonderful and provided a lot of strong information for our newest board members. And we welcome all our new board members to AKAM. We're thrilled to have the opportunity to work with you. And if there are any questions that you might have, please feel free to email any one of us, or feedback@akam.com, and we will get back to you as soon as possible. Have a great day, and thank you so much.